To Europe now, the European top right court has ruled that employers cannot snoop on their employees' private conversations unless they inform them of monitoring their emails and chat conversations in advance. The ruling pertains to a 38-year-old Romanian Bogdan Mihai, who was sacked over using company's official communication system for private use. He was sacked after being found to have chatted with his fiancée and brother on the system. The judges said that Barbulescu's bosses and Romanian courts had not adequately protected his right to respect for his private life. The sacked employee argued that his employer invaded his right to privacy by spying on messages which included details about his personal life. The European Court's ruling also overturns a previous ruling that said that employers were justified in snooping on their employees. And on this very issue, I'm joined by our bureau chief in London, Mandy Clark. Mandy, good afternoon. Thank you for joining me. So this is, I would say, a historic rule which says that no matter what is the case, that your employer cannot sniff into your private business without prior notice. How big a problem is this in Europe?
That is the key bit, is that without prior notice, people have to be aware that their employers are actually looking at their private messages. Now, in this case, he was using a messaging system that was run by the company. So it was he was expected to send messages to clients, but he also used it to send private messages that pertain to his health and private matters to his fiancée and his brother. But the important thing is the European courts certainly say people have a right to a private life, and your employer cannot interfere in that. So unless you are using a company private system and they tell you beforehand that they will be monitoring your messages, they simply don't have a right. It certainly is a step change, because this isn't the first time this case went to court. In fact, in two other rulings, the Romanian courts had sided with the employer, stating that he didn't have a right it was the employer who had the right to look at those private messages because they were happening at work time. So it is a step change, and since it's in the European court, it's a European-wide law now that has, a ruling that will be precedent and applicable all over Europe.
Thank you very much. This was Mandy Clark, our bureau chief in London, helping us to make sense of the European Court of Right ruling that your employer cannot sniff into your personal affairs unless you are noticed on advance.